on the SEP licensing and proposed legislation in the European Commission. So we are joined today by distinguished guests in all respects, and unfortunately, Keith Mallison's name and position were omitted from the program, but he is in fact a consulting economist who's been deeply involved in the issues that we'll be discussing today. So without wasting any time, because what you need to know about anybody is in the program except for Mr. Mallison, and we can begin. George, if you would, Professor Contreras.
Sure. Thank you very much, Judge. So is this? Sounds good. All right. Thanks so much. So I'm George Contreras. I'm a law professor at University of Utah, and I thank the organizers and Judge Ginsburg for inviting me to speak with you. So we're focusing on the European Commission's SEP proposal, and I am going to kick it off by talking about one of the four elements of the proposal, right? There are four elements: creation of an SEP database, essentiality checking, FRAND rate determinations, and aggregate royalty determination. And so I'll talk about aggregate royalty determination. And what the proposal does in this regard is it permits SEP holders to notify the EU IPO Competence Center, newly created center at EU IPO, if they have agreed on an aggregate royalty for a particular standard, and then the center will publish that rate. They can also request that the center appoint a conciliator to help them and mediate their discussion about the negotiation of an aggregate rate. But probably the more important and controversial part of this proposal is that if they haven't agreed on a rate, no later than 150 days after the publication of a standard or the first sale of a product implementing the standard, any SEP holder or implementer of the standard can request that the center provide a non-binding expert opinion on a global aggregate royalty for the standard. Once that request is made, the center will then invite all known stakeholders to participate in a process of figuring out the aggregate rate. And if SEP holders holding at least 20% of known SEPs and either implementers representing 10% of the relevant market share or 10 small and medium enterprises, SMEs, if they express an interest in participating, then the center is going to appoint a 3-person panel of conciliators to create that expert opinion after gathering evidence. And they're supposed to do that within 8 months, although there's some fairly confusing language about extensions that can be granted at the discretion of the panel. The opinion that the center creates will be published, will set out the relevant evidence that they received, excluding confidential information, and the methodology that they use. And whatever the determination is going to be non-binding. Okay, so why have this element of the proposal? It's around the idea of bottom-up versus top-down FRAND rate determinations, right? In general, if SEP licenses are negotiated bilaterally between SEP holders and implementers, or if patent SEPs are asserted in court or in an arbitration, the rate determination is made as between those two parties, the SEP holder and the implementer, but generally without significant regard to the SEPs and also the non-patented technology that also is incorporated in the standard. And so you don't get all of the input into the technical discussion that you would have if more people participated. The royalties that are determined are done in an uncoordinated manner between these different proceedings, arbitrations, and negotiations. And so you don't have a systematic way of adding up all of those individual determinations to come up with what the total royalty might be for the standard. And the result, we showed in a paper a few years ago, just looking at judicial decisions in the United States over a few years related to the Wi-Fi standard. Just 35, or about a little over 1.5% of the Wi-Fi patents ended up yielding total royalties of about 4.5% of a router value or other Wi-Fi implementing product value, which seems like if you extrapolate it out to more patents could be higher than it ought to be. So back in 2017, in its communication about SEPs, the Commission observed that an individual SEP cannot be considered in isolation. The parties need to take into account a reasonable aggregate rate for the standard, which is what emerged this year in the proposal. Overall, I think this is a positive feature of the proposal, although I do think that it could be improved in a number of ways. One of which is that even though the center expert opinion talks about the aggregate valuation, it doesn't talk about the allocation of that aggregate rate among SEPs or SEP holders, which of course is going to be an important piece of this equation. And it is a piece of the equation that patent pools regularly do. Right? Determining aggregate rates for patents covering standards is not new, and it's not particularly difficult. It's been done for decades by patent pools, including the Avanci pool, which includes the 2G, 3G, 4G, 5G SEPs that are the subject of much of the debate in the FRAND litigation that's going on today. And Avanci, with the coordination of SEP holders and implementers, has come up with per vehicle rates for different combinations of SEPs covering these different standards. And you may think the rates are too high or too low, but they are rates, they're uniform, they're transparent, and that system, despite some litigation, does seem to be working well. So I will not monopolize the time. I know my time is up. I do think there are some other technical issues with the proposal that could be fixed and addressed, and I'm happy to talk about those later. Thank you.
Thank you very much, George. This gives us a good foundation for everyone to be clear about what is involved. And so we'll turn to Keith, if you would. Keith Mallinson.
Thank you very much, Judge Ginsburg, and thanks for CIP2. Often at these events, people say, "Oh, Keith, what do you actually do?" So I am a little unusual, so I'll just a few words. I'm something of an economist, but I generally describe myself as an industry analyst and business consultant with my firm, WiseHarbor, with offices in Boston and the United Kingdom. And what I've done is analyze markets and competition in mobile communications for decades, including technologies, equipment, and services markets. But I've taken a particular interest in technology standards development and SEP licensing. And so incidentally, I've published numerous articles supported by lots of facts and empirical evidence on the latter over the last dozen or so years. So you may be interested. For example, I've written 19 pages about aggregate rate setting. I submitted it to the European Commission in response to its request for feedback on the recently proposed SEP FRAND legislation. I also wrote a couple of papers in 21 and in 2022 on essentiality checking and patent counting, where I measured inaccuracies, including biases with random sampling and real-world essentiality checking. So if you're interested, all my articles are listed and hyperlinked on the WiseHarbor.com website. The European Commission's purported objectives are to improve the SEP licensing system, including providing transparency and predictability. So, for example, to SMEs who have little or no expertise in licensing. If that's the case, in my opinion, they should be seeking more disclosure to reveal existing rates and interpret them in the context of other terms in executed licenses with respect to the corresponding licensed trade, i.e. licensed product, volumes, and selling prices. Instead, they seem to be trying to reinvent the wheel by making stuff up and setting aggregate rates and apportioning them. Certainly, there's implicitly that there's the apportionment as well. Just a couple of additional remarks on aggregate royalties. There are two purposes for this maximum rate. Number one is to provide implementers of some idea of how much they should budget in total for royalty payments. Second is to use the figure as a notional input figure for apportionment in top-down rate analysis. One of the Commission documents, I think it was the impact assessment, they said that this is you get the aggregate rate, and it's the first step towards apportionment. Anyway, I say it's a sort of notional figure because much of the apportioned maximum rate is actually never paid due to patents that remain unlicensed and for various other reasons. So we are actually really talking about two different figures, even though they seemingly go with the same name. Setting an aggregate royalty is also tricky because that could be a fixed price per unit, an ad valorem percentage rate, and in many cases licenses are agreed for lump sums. So I'll focus now the rest of my remarks on the issue of essentiality checking. First, what do we mean by essential? IPR policies such as ETSI's for the cellular standards, including 5G, only require that patent owners declare whether patents might be or might become essential. Standard-setting organizations simply want to ensure that their standards are not blocked. However, declarations and counts of declared patents are also used by others in the more exacting context of licensing and FRAND rate setting. The question of whether is so-called over-declaration often arises in the latter context. Declared essential patents are checked in an attempt to correct for this. As I explained in my first of two submissions to the European Commission on its proposed SEP FRAND legislation, there are two purposes for checking essentiality. Firstly, to determine whether a patent holder has any patents at all that are standard essential. If any of these are valid and infringed as well, this would entitle a patent owner to FRAND licensing. In many cases, licensors have patents that have already been found essential by the courts. Alternatively, checking perhaps no more than a few dozen patents in a portfolio would ensure high confidence that at least one or two patents are essential. The second purpose is to use the count of the licensor's checked essential patents in the numerator versus the count of all patents checked essential in a given standard in the denominator for apportioning an aggregate royalty. And that is hugely more ambitious, impractical, and too costly an endeavor, in my opinion. There are simply too many patents to check, tens of thousands to some standards, to use SEP counts as a measurement system like this. Checking is inherently inaccurate and biased. Even random samples to reduce numbers of patents checked and have them checked more thoroughly would be prohibitively large, in the thousands of patents per owner. And of course, patent counting kind of assumes that all patents are of equal kind of value, and it ignores validity. So it's questionable as a valuation and apportionment method in many respects. So it seems that the European Commission wants patent counts to be used to apportion aggregate royalty rates using the top-down method. But court decisions, including Interdigital versus Lenovo in the UK, have typically rejected this method in favor of using comparable licenses. Where the method was used in Unwired Planet, it was actually applied downside up, only to infer a hypothetical aggregate rate as a cross-check to determinations based on comparable licenses. Justice Burse was unwilling to set aggregate rates, regarding such rate-setting proposals as being self-serving and about other people's money. One final comment. There's an interesting, unsurprising, and logical error in the online blurb describing this panel session. So this is my retribution for not being in the printed copy. But actually, it's interesting to reflect on this. It is not the European Patent Office that is being proposed to preside over aggregate royalty rate setting and FRAND rate apportionment. It is instead the EU Intellectual Property Office, the EU IPO, that is responsible for trademarks and which has no expertise at all in patents, let alone SEPs, that is being given the job. However, This is a popular choice for many, including the EU's Spanish presidency, because it's based in Alicante, Spain, which is also where many Northern Europeans like to go and sun themselves on vacation by the Mediterranean Sea.
Thank you, Keith. Roya, would you take over?
Thank you very much for inviting me, and a big thanks for putting this conference together. I think it's very interesting. I would encourage the organizers to even have the courage to be more diversifying in inviting people with different opinions. I'm sitting on a panel with Americans and Brits. I seem to be here the only one who's European. I tend to think it's important that Europeans get a chance to speak about Europe. And it's great that this was reflected here to a minimal extent. A couple of things I would like to say. I'm actually an IP evaluation expert, and I'm involved in quite a few cases to determine front rates. So I will not be discussing front royalty rate determination while I'm being filmed. I hope you understand. I will instead focus on other questions which I find equally important, exciting, and interesting to talk about, and I hope we'll have an interesting discussion about this. I have worked with the European Commission together with Justus Baron on the EC expert group, and it was less straightforward, George, as you describe it now. I cannot tell you that. It was way more controversial in terms of how and what came out and how it evolved. I think what we are seeing here from an international perspective is a massive tension between nationalism in intellectual property law and the dire need for internationalization, for globalization of patent law. And this expression from the European Union must be seen in this context, in this tension between national and international. And at the same time, the other string of thought which keeps bouncing in my mind is that because of the dire need to fill a global governance gap, we are seeing here different parts of the world react in a very different way to the same question. Europe has traditionally believed in strong institutions and in involvement in government and in a welfare state. That's been very much our model. So it's somehow not surprising that we came up with some sort of welfare state is looking after you and is going to fix it because governments just know what's good for you type of logic. This is not a US approach to things. And absolutely not. I mean, you're basically out to make your career. And I heard in the beginning that the dean of the school talking about entrepreneurship and how the American dream came true apparently in George Mason University. And I wonder to what extent this hasn't at this time, in an aspiration for global hegemony, acted to the disadvantage of the United States, because Europe filled the gap here in terms of saying, well, this is how things are supposed to work internationally, even including the United States. Wow. So I wondered how long US and also China are going to accept this, and maybe we may see some sort of anti-suit injunction reaction from other parts of the world on the same question. Who is going to rule on global questions? That's the first thing. The second thing, I think, is that this masterpiece from Brussels emerged pretty much at the same time as the Unified Patent Court saw its day of light after decades of struggling. And I wonder to what extent there was a consistent collaboration between various European institutions. I heard from some judges that they thought they would be doing this job, so they were kind of surprised that Brussels is doing the job in terms of figuring out how to go along with that. And I think there will be a certain need for coordination among different European institutions. And in this whole strive for setting a global understanding based with our different identities around the world, we're also still having the Brits in there who are also eagerly watching and rather not keen on being European. So how all of this cannot be ignored when we are talking front and standard essential patents. What I hope personally is that we can leave nationalism behind us, and that we can really find a global international IP system, because our markets are international, we have people from around the world, and we need to come together. If and to what extent what Brussels has written at this instance is going to be the last solution and last answer to this, I really doubt it. Thank you.
Thank you, Roya. Before we begin further crosstalk, we want to hear from David Kappos on some of the other additional policy implications raised by this proposal were to become effective.
Yes. Well, thank you, Judge Ginsburg. It's a real pleasure to be here. Thanks again for the CIP2 folks for putting on another great program, and Josh and everyone here for running an institute that is really, I wish it weren't so unique in the world, but it kind of is, and we all appreciate that very much. And it's great to participate again. So I was asked to pull up the rear, if you will, with commenting on policy and innovation and global implications that come from the Commission's proposal. But I'm going to go a little bit off script because there's a few interesting points that have been raised. Starting off with, Roya mentioned the, and I'll use my own words, the reflection of this proposal as a kind of a example of Europe taking on a global regulatory role. And as we saw with the GDPR, in the privacy domain several years ago, the so-called Brussels effect has worked. It really has worked. In some ways for good, in other ways, maybe not so great, but it has worked. I was shocked on a recent panel I was on with Eustace, when, who you mentioned, Roya, was, I guess, in the same group as you that was advising the Commission in coming up with the surprise proposal that they came out with, when it was revealed that this is all, part of a master plan of some in Europe, and I'm trying to channel what I was told, rather than characterize it myself. But Europe recognizing that it is difficult for Europe to compete with America and China in innovation, but one thing Europe can do is be the world's regulator. I was really shocked when I heard that, but I feel like I'm hearing echoes of it here also. So to talk about policy, you have to start by saying, this is big stuff. This isn't just Europe qua Europe, right? And the reason that Americans are getting involved, and we're talking about it here at a conference just outside Washington, D.C., and the reason that I have personally submitted comments with other former government officials is because this isn't just Europe. This is the world. This is Europe and America either teaming together or not teaming together, and it's a really bad sign when we're so far apart on something that's so fundamental. So starting off with policy implications, it's hard to say that the policy implications are good here, transatlantic. It's also hard to say that they're good for innovation writ large, because what's happening is the Commission is essentially choosing sides as between producers and consumers. And government usually tries to avoid that, or I would say as a matter of policy should try to avoid choosing sides and generally should let markets work with some edge case exceptions. But in this case, there's definitely choosing of sides on the side of the consumers, in this case, consumers of SEP-based innovation. So I think that's not a great sign policy-wise also. In terms of where this takes innovation and the innovation implications, I think unfortunately, again, not a good direction. This is a move that is, at least at the margins, and the margins are important here, going to incent innovators in the SEP area to make decisions to remove their innovations from the standard setting process. And I've been involved in discussions where those kinds of things are talked about. So it's not just theoretical, it's really something that gets considered. So you're going to see, again, at least at the margins, some contraction in the innovation that goes into the standards, in this case, that, practically standards around computing, telecommunications, et cetera. And it's not great to see innovation going out of standardization and going into, a more balkanized, call it walled garden kind of world. So that's not a great innovation implication. I think it also is probably depressive toward investment in innovation more generally, because those who invest in innovation, and I'm really talking about the private equity funders who are contributing, if not hundreds of billions of dollars, many hundreds of billions of dollars in aggregate, people in New York, where I live and work generally, as well as the VC industry, which is putting the hundreds of billions of dollars behind innovation that it takes to get an idea into the marketplace in a big way. And again, at the margins, they're going to shift their investments. They're going to shift them to other areas, as they already have been in some cases and already are. And that's not good for innovation solutions in this area. And then lastly, Judge Ginsburg asked me to comment on global implications. I think some has already been said about that. But a finer point needs to be put on the fact that, look, and I'm not anti-China at all. I've done lots of work in China. I love a lot of what has transpired there. Not everything, but a lot of it. And nevertheless, I will say, I really would rather a balanced global approach and an approach that's based on the rule of law rather than rule by law to dominate in establishing global royalty rates. But that's probably, ironically, not going to happen as a result of the EU proposal. Instead, it took only a few months after the EU put its proposal out for SAMR in China, the powerful state antitrust regulator, which is also the home for CNIPA, to put out an initial declaration of China's SEP royalty rate setting approach, which is very much emboldened and enabled by the European approach. So I think where we're likely to head is that, people in this room can decide if it's for better or worse, but for whatever, China being the global royalty rate setter for SEP-related standards. And that, I think, is going to have some important implications as well on the global level. So that'll stop there. Lots more to talk about.
Thank you, David. That was very, what should we say, distressing. But okay, Roya suggested you had a rather Pollyannish view of the proposal. What do you think? What do you think?
Well, as I said, I do have my critiques of the proposal, so why don't I talk about some of those? And they get to some of the things we've been talking about. And, my background is really in representing and advising SDOs. I spent 20 years as the legal counsel to the Internet Engineering Task Force, and I've represented a number of SDOs around the world. And, I have to say, from my own experience, interoperability standard setting is a truly amazing international cooperative effort. It's something like the world has really never seen before, and I hope we don't mess it up as a result of these governmental initiatives that we're seeing now. The problem is, though standardization is an international activity, patents are national in scope. And this disconnect is where we get a lot of our problems, right? The best or most logical outcome for all of this would not be a world government or a world patent or anything like that, but some sort of voluntary international rate-setting procedure that either parties or SDOs or somebody agreed on that would set these aggregate royalty rates across the board and that would be respected by national courts. The problem that we have is that we don't have such a voluntary system yet, and instead we have individual countries and the judiciaries in individual countries jockeying to become the preferred venue for SEP rate setting. So you have the courts in the UK who have taken this on, you have the courts in China, and now we may have the EU IPO jumping into that fray as well, trying to become the global rate setter for the world. And one of the things I object to in this EU proposal is that both the FRAND rate setting and the aggregate rate setting that they would do is not limited to European patents. It's global in both cases. And that, to me, seems like a problem. If the EU IPO process were limited to rates for European patents, then the determinations that they put out might actually dissuade courts in other regions like China and the UK from presuming to set rates for the European Union, since a competent European body had already done that. But if the Europeans instead are simply going to jump into the race to set the global rates before the UK or the Chinese or anybody else, then it doesn't seem to be helping to solve the problem. So I would pull back from this European proposal and, have the Europeans address Europe. The US courts, despite implications that we're looking for some sort of global hegemony in this area, that's absolutely not true, because it's the US courts that have been probably the most modest in their limitation, even in the Eastern District of Texas, especially there, to trying to assess rates for US patents in the US as opposed to global rates. And so I think that is probably the model that most quickly gets us to an international agreement around this, when courts just stick to their own jurisdictions, their own borders, don't try to expand their influence to the entire world, and again, hopefully get us to a voluntary system where these rates get set in a way that's agreeable to all the participants.
That leaves a very different light on things. Thank you. Keith, I think you were trying to get in there.
Yes, I'd like to echo some of the things that have just been said in terms of what we have. As George was saying, standard setting is an example, perhaps the paramount of human kind of coordination. If you think of what's going on in 3GPP and in setting the cellular standards, you've got all these standards groups meeting repeatedly, and they've done a terrific job. And as a result, we've got a very vibrant and innovative and successful technology sector in, for example, that particular standard and in other areas. And so we have to be careful that we don't kind of mess with this too much. And I think there is some danger that this is what's going to happen. And as David was saying, there is a danger if we do that we'll end up with some kind of reversion to more kind of a fragmented system where we have proprietary approaches as opposed to the benefits that we've got from everyone adhering and following the same kind of global standards. And there is a strong consensus that we want to try and preserve the global standards development system. I think that Europe is actually shooting itself in the foot, the European Union. Incidentally, the UK does still sometimes regard itself as being part of Europe, if not the European Union. I believe the Swiss probably think of themselves being European in some kind of way too. But where was I?
The other Europeans.
Yeah, just think what the deal is here. Well, first of all, we're talking about disputes and such like. Let's not forget that the vast majority of this SEP FRAND licensing goes on very quietly and successfully and globally without any fuss. So what we're talking about here is when there are disputes and how to deal with that. But the deal really is this. as a technology developer, you're willingly commoditizing what you have created, making everybody have that technology available, freely available, openly available for everyone to use. So you're commoditizing the downstream market. So on that basis, you have a right to be able to derive a decent royalty rate to compensate you for the innovative work you've done upstream. And I think that this initiative is dangerously messing with that. And particularly within the European Union context, because you have two major, in the context of cellular at any rate, you've got two major innovators that are investing approximately $1 billion a year in developing, for example, the cellular standards and other technologies as well in the shape of Ericsson and Nokia. And they have royalty income of that kind of level as well. And so I think there is a grave danger that's going to be disrupted. I do think that, okay, so we need to preserve the global standards setting. We have a problem, clearly, when it comes to patents, because they are national rights. I mean, where there are disputes, there needs to be some sort of more globalized solution. I think this initiative in Europe is not particularly helpful. There is latently in the United States, there's the SERA Act proposal, which has some similarities to what they're doing in what's being proposed in Europe. It seems to be relatively quiet in terms of that development. I don't know whether our US colleagues have got anything to say about that. And when we were preparing for this call, sort of one comment was, well, you know, maybe the US is just waiting to see what happens in Europe and then deciding what to do next. You know, alternative dispute resolution, I think, can be quite valuable, where that can actually provide a global solution. But I think we do have a problem still. We don't have the anti-suit injunction warfare that we had a couple of years ago, but we still have a bit of a fractured system in terms of resolving these disputes.
Thank you, Keith. Roya, did you want to say something about ADR?
Less about ADR, just what I tend to think more. I mean, the approach Europe is taking is that it is proposing a centralized government institution to regulate markets. It is beyond my imagination to see that ever happen in a US context. And the question will be, which of these governance structures will be more effective and efficient to assure entrepreneurship and innovation? A centralized administration or a free market system or something in between? That will be the issue really here at stake. And the other point is, when Unwired Planet versus Huawei came out, I said it in the outset, I said, this is post-colonialism. And I said at the time, this will have this, if the British go ahead with their ideas of internationalism, the US will react, China will react, and they totally did. So I think this is the real issue here, is this massive tension, nationalism and internationalism, and the patent system needs to become international. But the question is under what paradigms? And this is where representatives from various parts of the world need to sit together and find a solution, I think.
Very big problem, global patent harmonization. I wonder if we could just bring this back for a moment to the EU proposal. One thing that a number of us have commented on, but I feel like maybe more needs to be said is, and for Roya, since you were involved in developing what became, with some surprise, the proposal, as I have read the backdrop to it, the value proposition or the statement of the problem, it's based on the questions about excessive litigation and uncertainty, and inability of the courts to manage royalty rate setting, for SEPs. However, as I think several people have already said, there's absolutely no sign, and in fact, the report itself admitted in its initial portion that there was no sign of excessive litigation in the SEP patent area, and I agree with that. And then you've got the fact that the courts, particularly at the ECJ level, as well as the level in Germany, have set forth, through extensive opinions, a nice body of law balancing the responsibilities of patentees versus those of licensees in the SEP area that has in turn caused litigation to, if anything, decrease and at least run at very, very nominal levels. So I found myself coming away from the justification feeling very empty, like this is definitely a solution in search of a problem, and it makes me wonder what is going on and what agendas are at play when there's no problem but a solution is being proposed. So I'll just sort of lay that out as another component of this proposal that makes me extremely skeptical that it actually is going to achieve anything positive or useful for innovation outcomes.
The people who maintain that holdup is a major problem also would say that the absence of litigation only reflects the ability of SEP holders to coerce settlements, favorable settlements. It's somewhat basically irrefutable claim for which there's no evidence, and maybe could be, but thus far is not. I must say, in following up on your point, David, that the claim made here in the proposal is almost laughable, I thought, in that it was claiming a justification that it would reduce transaction costs for parties on both sides of the issues, both the implementers and the innovators, by centralizing information and by forcing them into the process, because if they don't notify within the 6 months, I think it was, deadline, then they're forever barred from collecting royalties for the period in which they had not notified. But and the Global Antitrust Institute, the co-sponsor for today's program, filed a comment with the European Commission on this, pointing out, among other things, that if it's true that the system would function to the advantage of both implementers and innovators through the diminution of transaction costs, then it ought to be made a voluntary scheme, and then we'll see. Do people on both sides, do they agree to come in? As it is now, only one side, either the implementer or an innovator may, and presumably will be implementers for the most part, may refer the matter to the new authority and invoke its to some degree coercive power to bring the other side in under a penalty, even though the ultimate FRAND decisions that they might make are not binding. So it seems like a self-contradictory and frankly ridiculous proposition.
I think most of the costs are going to, these increased transaction costs are going to fall on the patent owners. It seems to be very unbalanced in that respect.
Yeah.
And meanwhile, they're suffering delays in their ability to be able to obtain the licenses. So I think it's extremely skewed in that respect.
I have a question that David made the answer to, and that is the proposal makes no reference to a bond requirement, no surety. Would that override or coexist with the requirement of the ECJ in the Huawei versus ZTE case that a bond be posted?
Yeah, that's a great question. I would think that's going to get litigated. I have no idea what the answer is there.
I mean, it's a question, I guess, of intra-European law, but I don't know the answer to that. Jorge? George, pardon me?
Yes, I do think that the proposal, as it was released, does allow a monetary, a preliminary injunction not to prevent use, but backed by some sort of monetary penalty. I'm scrolling through, I can't find it, but I think there's something about that in there. Well, can I respond to just
Please do. Yeah,
just two points. I mean, one, again, I do think that the proposal is problematic in some ways, but that doesn't mean I agree necessarily that there's no litigation problem in this area. I mean, I do think that the fact that we have inconsistent litigation outcomes, even with respect to similar patents covering the same standards as implemented in practically identical products, that seems problematic. And the fact that in the private bilateral negotiations between SEP holders and implementers, there's very little transparency with respect to the rates and the terms because it's largely covered by confidentiality agreements, that I think is problematic in assuring that the non-discrimination prong of FRAND is met. And then the unpredictable results that you can get, not even as between courts and in different countries, but even within the same country, that makes planning difficult for companies on the implementer side. So I do think that some movement toward greater coordination is warranted. And again, my personal perspective is that the way that patent pools achieve this is a efficient and useful and valuable way, again, that we have seen work with the exact same patents that we're disputing right now in the mobile telephony space. This seems to work just fine in the automotive space and soon to be the smart meter space and the other areas that Avanci has taken on. In terms of costs, we haven't talked about this registry yet, and so it's worth spending, I think, just maybe 2 minutes about the registry, which it could become quite an expensive undertaking, right? A registry of all the SEPs, and you have to include your SEPs in this thing in order to assert them. It's a project that is largely duplicative of what a number of SDOs already have. So ETSI, ISO, IETF already have databases of patents declared against their standards. And most people in the industry seem to know that and consult those databases, and they're not the easiest to use all the time, but they get the job done. And so there's a lot of duplication there, but there are two areas where some sort of registry could help. And that is for the SDOs that do not have their own database or even a specific SEP disclosure requirement, that have blanket disclosure requirements like IEEE. The 802.11 Wi-Fi standards body doesn't require the disclosure of individual patents if you make a blanket FRAND commitment. And so there's a lot of questions out there about which patents are actually essential to Wi-Fi. And all you have are estimates by different consulting groups. And so as a researcher, I would be interested in something more definitive. And the second area where a registry would be helpful and interesting is with respect to SDO outsiders. We haven't talked about this before, right? But everything we've been talking, the FRAND commitment, the registration requirement, the database requirement, that all applies only to SEP holders who are participants in the relevant SDO. Outsiders who develop patents and technologies that might read on standards, who do not do it within the SDO, they're not bound by anything. Yet they do sometimes assert their patents. And we saw this surprisingly even with Bluetooth, which is a royalty-free standard. Nevertheless, you have an assertor who went around and sued Samsung and other entities and got large jury verdicts in the US from that. That was a complete surprise. And under the European registration system, in order for an entity like that, like Rembrandt, to bring suit on SEPs that are not part of the SDO, it seems like they too would be required to register their SEPs in order to bring suit. And that's an interesting development that I think no one has really talked much about, but I think would be one useful thing with the registry.
So can we just do a little fact therapy on a few of those assertions? One of them that comes to mind is the notion that there's a lack of transparency about royalty rates. I would tell you there's never perfect transparency on those things. The license agreements that are frequently involved between licensors and licensees can run over 100 pages, and they cover many, many topics. But one thing that's become really transparent is the royalty rates themselves, whether it's through Avanci, which has been mentioned, which has got access, I believe, to well over 95% of the patents involved in 4G and now 5G, which openly publishes its prices. Major licensors who openly publish their prices. So I don't really think there's a significant problem with price transparency. Is it perfect? Well, nothing's perfect. This is a really complicated area of the law. If it were simple, we wouldn't need to be talking about it. But I would tell you, price transparency on access to licenses for these extremely important standards, it has actually gotten a lot better. And if that's the problem that the EU IPO is solving, that's, in my mind, extremely strong evidence, additional extremely strong evidence that they're making up problems to solve.
Yeah, I mean, as I said in my opening remarks, what they appear to be doing here with rate setting is making stuff up. If transparency is the issue, then why not do a better job at finding out what's actually out there already, where you've got extensive licensing. Now, in the case of patent pools, as David has just said, it's actually very transparent already. It's very clear what's going on. You can see. I mean, you go to the websites of like via LA, and you can see who all the licensors are, who the licensees are. The patents are all listed. It's really it's as clear as a bell. Interestingly, with some of the litigation that's occurred recently, particularly in the UK, although the decisions are redacted, I think we're getting quite a clear picture of what's going on. For example, in interdigital Lenovo versus Lenovo, clearly the non-discriminatory aspect was very significant, and you could see what was going on with the different licenses there. So I think if you're going to create databases, first of all, to echo what David's saying, I mean, we already have a database with ETSI for the cellular standards. It can be improved, but no need to really reinvent that particular wheel. But what could be done is some kind of repository could be created of licenses, of licensing terms. I think also has to be coupled with that, not just the licenses, but actually the trade that's associated with them, because it's clear that sometimes licenses are kind of, rates are kind of created for kind of cosmetic purposes, and there may not actually be any trading behind them. And then, of course, that doesn't completely fix it, because even if you're doing a comparable license analysis, somebody has to actually look at these. How long did you say the licensing agreement was? A couple of hundred pages or something. So there's actually a lot of interpretation that needs to be done as well. I mean, they use this term unpacking, and particularly if they're cross licenses, there has to enormous amount of unpacking that has to go on. So that's actually quite a significant a significant challenge. But it's a better route to go than just saying, well, let's dream up an aggregate when they're really, and then apportion it using a very crude kind of approach, and one that incidentally has been significantly rejected by the courts. So the top-down method was rejected totally in interdigital versus Lenovo. It was used in a kind of way in Unwired Planet, but I think the subtlety is often lost. It was used, as I said in my opening remarks, it was used the other way round. I would like to call it in a bottom-up manner, but unfortunately that term was taken to mean something else. So you can't really use it. But what you do is you actually imply an aggregate, and that is entirely different to, like with the power of God, deciding what the aggregate should be and then apportioning it. Because in Unwired Planet, they were merely using it as a cross-check. What is the implied rate? So that would be my prescription is go, if you want more transparency, try to find out what's really there rather than making stuff up.
We have to, in 1 or 2 minutes, turn the matter over to any questions we have from the audience. Before doing so, I'll ask everyone on the panel what you can tell us about the situation at the WTO. It's my understanding that Europe, of all things, has filed a complaint under TRIPS against the practice in China of imposing worldwide and perhaps very low royalty rates, and that the the U.S. and Canada have sought to intervene on behalf of Europe. Is any prospect of improving the situation at the WTO? Anyone?
Just to offer a view on that, it's a long haul. I applaud the Europeans on taking the lead and filing and sort of standing up to that issue and shedding light on it. And I was pleased to see the U.S. Intervene on the side of the Europeans. WTO cases in the past, in my recollection, have not tended to really resolve anything. So I feel like good try, let's see how it goes. But I don't think we should wait for the outcome and expect it to solve the problem.
Yeah, I agree. I don't have great hope for it. And in fact, I think that the EU's complaint is even more modest than Judge Ginsburg, I think it's primarily a procedural complaint that the Chinese haven't made available some of their decisions and so forth that affect European parties, which is problematic, and I think it is a problem, but I don't even think it gets too much into the substance of what the what the problem is. So I don't hold out great hopes.
In the absence of that, we have now we have China's issuing anti-injunction orders along with the decisions on royalties. We have anti-injunction orders coming out of, I believe, German courts, and anti-injunctions, presumably again from China. Not a stable equilibrium, I think we can say. So questions from you all? Sir? Is there a microphone to go around?
Yeah.
Oh, there it is, okay. Yeah, so if anybody wants to, please approach the mics.
So, hi, I'm Fabian Goodell from Conf, and I'll preface, I don't know if this is working. I'll preface my question by saying the original proposal I don't think would have required.
No, that's better. No, good, I don't have to yell. The original proposal would not have required Rembrandt to register because it applies to patents that have been FRAND committed or license committed, say, in the Rembrandt canon. So that wouldn't help. But my question is about now proposed amendments that I think are interesting and a significant change to the proposal that are in both the URI and IMCO committee reports. And I don't expect you guys to have read them because it's not your job like it's my job to prepare for a world where this actually happens. But what those amendments do, or would do, the amendments I'm thinking about, is change the application from essential patents that have been FRAND committed to declared patents regardless of a FRAND commitment. And I'm interested if you have any comments or thoughts as to how that would change the effect. At least that it would then cover the Rembrandt case, George. So you kind of pre-anticipated my question that way, but certainly the declared also affects something that you said. So I'm interested in your thoughts.
Yeah, so that's a a subtle but important change if it's adopted, right? Because, and tell me if this is where you're coming from, Fabian. But you clearly in groups like IEEE, there have been numerous declarations of patents that the SEP holders have not agreed to license under the SDO's FRAND term, or then current FRAND terms, perhaps offering pre-2015 FRAND terms from that SDO that are more to their liking. And then if the registration requirement required for those patents, then you need the registration, you need to go through these procedures for those patents as well. And like, where does the FRAND determination then come out for those patents? Would the board use the post-2015 or the pre-2015 sort of FRAND set of factors? And I don't know. That's a really good question. I mean, I would say I just wanted to just a second on that point to Keith. That I don't think that in any of these cases the EU IPO would just be making it up. I mean, I think that's an ungenerous characterization, because they do have this whole procedure for requesting evidence from the parties, and any SEP holders who want to come forward and present evidence like this database of licensing information would be fabulous. I think that would be a wonderful thing, and you may get that if enough SEP holders come forward with that evidence, which is in their own self-interest to do so, to prevent the EU IPO from just going off on a tangent and making something up. I don't think they want to.
Yeah, I mean, for the aggregate rate setting, I mean, there is no indication of what the right approach for that would be. I mean, it could be some kind of regression model, some sort of hedonic pricing model, conjoint analysis. It could be with reference to existing licenses. Who knows? The notion is, and this is strange, I mean, you hear different stories about how the EU IPO is going to operate. We have these conciliators and assessors. The idea is, I think a lot of them are going to be subcontractors. They're not actually even going to be staffers. And they're going to have, wise people are going to come in and figure it out. Okay, they're proposals of what aggregate rates may be, but at some point somebody has to make a decision. And I don't know where the kind of intellectual kind of guidance should be on that. But one thing I will say, I mean, they've got a lot, they'll have a lot of work to do. If you just think of what goes on in litigation, just take a recent case like InterDigital Lenovo. You've got experts on both sides. You've got tens of millions of dollars being spent on expert fees where they're trying to figure out what these rates would be, trying to unpack, to figure out what the FRAND rates are and such like. And there's massive disagreement between the two sides. So you've got a lot of expert capability there, but they don't converge on a single kind of truth as to what the aggregate is or should be. So I think it is kind of making stuff up, actually.
Well, let me ask if then, before we take our next question, since the decisions would be non-binding and serve as evidence in court but not determinative, and courts are rejecting top-down determinations, apart from the delay, just looking at the substance of how they reach their decision doesn't matter. What reason is there to think that these decisions will be respected?
Well, I mean, the fact that it's got the EU IPO stamp of approval, I think will have some kind of sway. Now, it just so happens in the UK, they've not liked top-down, and it has been used a couple of times in the US. I don't know where it will end up in future.
The parties are definitely going to challenge it, right? I mean, I think you've seen exactly what's going to happen. If these are not binding, and as written is not binding, they're going to be challenged every time. like one of the parties is not going to be happy, maybe both will be unhappy, and then it will just be a waste of 9 months.
Right.
And great cost.
So,
Yeah.
so much for taking costs down, right? This is going to
Yeah.
cause them to go up.
Yeah, which is like more holdout. I mean, that's really, it's not very balanced,
I think they should be binding. I mean, you know,
which is what the US wants to do with Sarah, right?
Yeah, I think they, in reality, will be close to binding. It's a little bit like the Inflation Reduction Act here in the U.S. and people saying, oh, well, the government getting to negotiate prices with the drug suppliers is just a negotiation. No, it's not just a negotiation. It's a dictation.
But, of course, the parties could agree ex ante to abide by the decision, right? So if these decisions actually were either persuasive or persuasive in court, such that there's not that much reason to oppose them, just agree in advance to abide by. You don't have to make it, George, you don't have to make it compulsory. Let's try to minimize compulsion.
so some of these parties don't even want to agree in advance to abide by a court ruling.
Oh, well, that's a problem. Sir?
Yeah, I mean, but one other thing that needs to be said about that, Judge Ginsburg, is that the reality is that innovators are actually happy to go to binding arbitration and accept the view of a neutral third party. It's the implementers who have refused to do that. So ask yourself, right, when you've got one side of the equation that's engaging in a concerted effort to drive prices down and has the resources to do that and has shown absolutely no inclination to agree to the decision of a third party absent a court after spending $50 million on litigation.
And
Is
yet,
this really
as you've
gonna work?
said, tens of thousands of agreements reached every year. The system operates overwhelmingly by itself. So let's take our another question. From, sir, you are?
Josh Sarnoff. One of the concerns, obviously,
Oh, yeah.
one of the, is it on? Yeah. One of the concerns is royalty stacking, and, you know, the converse concern is collective price fixing. So what nobody said, I mean, presumably the EU activity is antitrust immunized, but isn't it better somehow to get everyone in a room to try to decide the relative contributions of the technologies and having this done on a case-by-case basis where not all the parties are actually in the litigation?
George, I think you,
I mean, this is what pools do. Pools do this, and it works. And I'd say, you know, how did Avanci come up with $15 per car, then $20 per car, then $32 a car? Who knows? But, you know, it seems reasonable enough, and if everybody agrees, what's wrong with that?
Yeah, but they're still not happy. I mean, the supporters of this EU legislation, the lobbying force seems to be mainly the big techs and the German auto manufacturers. So they've all signed up to Avanci. They're all Avanci licensees, but they're still not happy. They'd like to pay less.
Yeah, so one other thing needs to be said, Josh, I don't accept the premise that royalty stacking is a real problem. I think that's a false problem. If anything, the stack should probably be higher. So here's some more data to the point that Keith was just making. We now have Ford offering Blue Cruise, hands-free highway driving built all over on top of 5G technology. The cost to buyers for 3 years, $2,100, right? Tesla offering for its full self-driving capability, which is only works because of 5G, $12,000 up front or $199 a month. Over the duration that you own the car, that's going to be many, many thousands of dollars. And it goes on. GM Super Cruise, $2,200 up front or $250 a month. The data shows that if anything, the stack isn't high enough. Avanci is charging a small fraction, a very small fraction of what all these companies and Mercedes, right, and on are now making by creating subscription services on the back of the 5G technology.
So you're saying that reflects the value of the
Absolutely.
the technology.
Can I just say something more about royalty stacking? Because this assertion has been around a long time. In the cellular industry, around about the time LTE was being introduced, there was great concerns that the royalty stack was going to be 30% on a $400 smartphone. And NGMN, which is an industry association of mobile operators, concocted this process to in the interest of increasing transparency. So this was transparency, the notion of it in the late 2000s. Get everyone to disclose their maximum terms, and we'll figure out what the royalty burden could be. And sure enough, they came up with a number of 30%, which incidentally they never disclosed publicly, even though this was supposed to be about transparency. I never understood why they weren't willing to reveal it. But everyone knew that this was nonsense, that no one was ever paying that amount, because there are all sorts of unlicensed patents. There's discounting, royalty-based caps, et cetera, et cetera. So what I set out to do in 2015 is to actually figure out what people were really paying. And I calculated it, and it was able to assess that really it was on a phone, it was less than 5%. And that ain't no stack. And really, there's no evidence that royalty stacking has been problematic. And I believe in U.S. courts, the judges have not been willing to consider royalty stacking without evidence actually being presented that it actually exists as a phenomenon. And none has been presented. So it's a fiction, this notion of royalty stacking. It doesn't happen for all sorts of reasons, which we could spend hours talking about.
The
But
problem
unfortunately,
with the analysis, though.
We don't even have minutes left. We've reached the witching moment here. There's going to be a 20-minute break at this point until 4:25, at which point we'll reconvene with a panel on the TRIPS waivers back here in the auditorium, and another panel on SEP licensing in France, so we can continue this discussion across the hall in the Van Meter room 126. So as we break, or before we do, please join me in thanking our panel's guests here. Terrific job.